I want to talk with you all today about some common tactics that insurance companies use to either deny or reduce your car accident claim. After a car accident in Kansas City, you would expect the insurance company to step in and help. After all, you've been paying premiums for your protection. But the truth is, insurance companies are businesses first, and their goal is to protect profit and not to maximize your recovery. This means they do use strategies designed to deny car accident claims or even reduce the payout that they give. If you're not prepared, you could walk away with far less than you deserve. This video today is going to explore some common insurance company tactics that we see them use on claims and how to fight back to protect your own rights. Why is it that insurance companies use these tactics? Well, insurance companies earn money by collecting premiums and they lose money when they pay out claims. Every adjuster's job is to close claims quickly and for the lowest amount possible. That's why after you're involved in a car accident, you may find yourself dealing with some delays and stalling tactics, some lowball settlement offers, attempts to shift fault onto you, requests for unnecessary information. Knowing these strategies ahead of time can keep you from falling into their traps. So let's first talk about their first tactic we oftentimes see, lowball settlement offers. One of the most common tactics insurance companies use after you've been involved in a car accident claim is to give a quick lowball settlement offer. They know you're stressed, they know you're facing medical bills, they know you may have car repairs and time off of work, and they know by offering you a small payout right away that many times people will accept it. But here's the problem. Once you accept it and you sign the release, you cannot go back and get more money. And many injuries worsen over time or are not discovered after some medical care. A fair settlement should include things like future medical care, lost wages, pain and suffering, potentially not just the immediate bills that you have. Another tactic they use is delaying your claim. One of the things they can do is drag the process out. Insurance companies may lose paperwork, ask for repeated documentation, or even change your point of contact. They hope that you get frustrated and settle for less just to get things over with. But one of the things you can do to fight back is to keep really detailed records of all communication and all documents submitted. And if delay continues, then an attorney can really push them to act in good faith. Sometimes they'll try to shift blame as another tactic. And the reason they do so is because of comparative fault, where they can reduce the amount of compensation based on what fault you may have in the accident. For example, if you've been awarded $50,000 and you're found to have 20% of fault, then you may only get $40,000. Insurance companies use this rule to their advantage, arguing first that maybe you were speeding, maybe you didn't stop fast enough, or maybe you were distracted at the time of the crash. But the bottom line is that even small percentages of blame can cut thousands of dollars from your settlement. Sometimes insurance companies will minimize or deny injuries. Adjusters may downplay your injuries or claim they weren't caused by the accident. And some common examples may be that you are just normally aging, or that you had a pre-existing injury, or they'll question whether or not you even needed certain medical treatment. It's especially common when we deal with soft tissue injuries, back injuries, or concussions, which really don't always show up early on scans. Requesting unnecessary statements or records can sometimes be what they do. It's not uncommon for them to ask you to sign certain releases, to ask for certain accident details or medical records, but sometimes they even go further. Some red flags include asking for all your medical records, not just related to the injury, pushing you to give a recorded statement early in the process, and asking leading questions really designed to cause you to admit fault. So if you're not required to even admit a recorded statement to the other driver's insurance company, always consult with an attorney to make sure you understand what you're saying and how it can have a consequence on your claim. Insurance companies will also deny claims for just technical reasons. Sometimes they'll just outright deny a claim by saying you're missing paperwork or you missed a deadline, that there's some policy exclusion, or whether the policy was active at the time of the crash. And while some denials may be valid, other examples may in fact be what's called bad faith insurance practices, where the insurance company refuses to pay legitimate claims. Finally, they may use your own words against you. Adjusters are trained really to listen to and to use your statements to their benefit. And even things like, I'm sorry, I feel okay now, can be twisted into admissions of fault or suggestions that you weren't really that injured. That's why it's always best to stick to the facts. Talk about the date, time, location, the vehicles involved, and just whether or not you're receiving medical treatment, nothing more, until you've talked to an attorney. So how is it that these approaches can impact your settlement? When insurance companies succeed with these approaches, your settlement check always shrinks. You could miss out on compensation for long-term medical care, future lost wages or reduced earning capacity, pain and suffering, emotional distress, or PTSD. For example, a fair settlement might be 75,000, but after the insurance company factors in their lowball offer, comparative fault, and minimize your injuries, they may suggest you only should receive $10,000, far less than you need to recover. So there are some steps to protect yourself. One of the things you can do is to document everything. Keep records of medical visits, missed work, accident photos, and communication with the insurance. Do not rush to settle your case. Wait until you really do understand the full extent of your injuries and the cost. Be careful what you say. Make sure to stick to the facts and avoid speculation. Know your rights. You don't have to give a recorded statement to the other party's insurance. And then consult with an attorney. An attorney can recognize and push back against any of these approaches that are used. Let's talk about a role of a Kansas City personal injury attorney. The role of the attorney is to make sure to advocate for you and level the playing field. They can communicate with the insurance company for you. They can collect evidence to prove fault and damages. They can calculate the full value of your claim. They can push back against unfair delays or denials, and they can take the case to court. Sometimes it's necessary just to proceed with litigation as opposed to negotiating with the adjuster. After you've been involved in a car wreck, I like to remind people that the adjusters may seem friendly, but their approaches are designed to save money, not to help you. Lowball offers, delays, or even outright denials are all some of their strategies they use to make sure you get less than you deserve. So if you've been involved in a car wreck, I strongly suggest you contact counsel to make sure that even playing field can exist between you and the insurance company, and that your resolution isn't minimized by some of their approaches.